You guys should be all set.
Thanks, Ryan. All right, good evening and welcome everyone to the City of Annapolis Board of Appeals regular virtual meeting for January 5th, 2021. This meeting is being broadcast on the City of Annapolis YouTube channel. My name is Bob Gallagher, Chair of the Board of Appeals. In accordance with the city policy during the pandemic emergency, this virtual meeting allows the public to observe the meeting through the video link and to submit written comments through the City of Annapolis website. Links to the YouTube channel and to the comment form on the website are available on the agenda for tonight's meeting. We'll start by asking our recorder, Tammy Hook, to call the roll, please.
Mr. Gallagher,
Yes.
Mr. Zazali,
Here.
Dr. Chen,
Present.
Mr. Burnett,
Here.
Mr. Walsh,
Here.
Mr. Dews.
Present.
All right. We've not only got a quorum, but everyone is present tonight. That's a good thing. So just a couple more notes on the virtual format before we launch into the agenda. The people that you see on the screen, if you're viewing at home, as you must be, are members of the Board of Appeals. When a case is called, the representatives of the parties to that case will also appear on the screen. Also participating in the meeting are Counsel of the Board of Appeals, Cheryl Woods, our Recording Secretary, Tammy Hook, one or more city employees working the technical end of things. Tonight we've got Ryan with us. Also participating, there may be other representatives from the city, including Dr. Sally Nash, Director of Planning and Zoning, Joelle Braithwaite, Assistant City Attorney and Counsel, Department of Planning and Zoning, and one or more other members of the planning staff. We ask everyone but members of the board to mute their audio. If anyone wishes to speak during the meeting, please raise your hand and I will call on you to speak. As I mentioned earlier, written public comments are accepted on the city's website. Comments on matters before the board tonight that were submitted up until noon today are made part of the record in that case. They've been forwarded to members of the board and to parties in the case. In order to allow additional comments in response to matters arising at hearings that take place tonight, the record will remain open in those cases in which evidence was received until our next meeting on January 20th, 2021. And the additional public comments received until noon on the day of the resumed hearing will also become part of the record and forward to members of the board and to the parties. Have the members of the board had a chance to review the agenda for tonight?
Yes.
Are there any corrections or changes, suggestions for changes?
No.
I have a motion to accept the agenda.
I move that the agenda be accepted as written.
Is there a second?
A second.
All in favor?
Aye.
Thank you. Let's see, the first item on the agenda is approval of minutes. We've got 3 sets of minutes. October 21st, December 10th, and December 16th. I recognize that not everyone was present for each of those meetings, so you'll just vote on the ones where you were present. May I have a motion to approve the minutes for October 21st?
I think we need to confirm who was at each one there. I don't remember.
Can you
I
help
was
us?
not at that one.
Can you help us there, Tammy?
Mr. Zazali and Dr. Chen was not present at the October 21st meeting.
That narrows it down.
I move that the minutes of the October 21st meeting be adopted, be approved.
16th.
Do we have a second there from Andrew?
Are you doing 16th or 21st meetings?
We're on the 21st.
Okay, sorry. The
All in
agenda calls for 16th first, but
Yeah, well, I do things backwards sometimes.
gotcha.
All right. Unanimous approval of October 21st. Now, December 10th. Anyone remember if they were there for that?
I move to approve the minutes for December 10th, 2020.
Is there a second? Somebody was there.
I'm reluctant in case I wasn't there.
I believe you were.
You were
I
there.
was there. I so moved. Second.
All in favor?
Aye.
Aye.
All right. And now December 16th.
I move to approve the minutes for December 16th, 2020.
Second?
Second.
All in favor?
Aye.
Congratulations. Next, we have elections. I'm not talking about Georgia. We have nominations for chair. So don't be shy.
I nominate Robert Gallagher as chair for the next term.
Second.
Any other nominations?
Oh, the whole slate.
I nominate Christian Cesali as vice chair.
All right. Should we consider that a slate? Are there any other nominations? Do we have a second for the motion?
Second.
All in favor?
Aye.
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 Well, congratulations.
Until such time that we're off lockdown.
Okay, now we get to work. Our first substantive matter on the agenda is Appeal 2020-06, 613 Chester. Ryan, would you like to bring in the performers?
Yes. Might take a second to sort through everybody, but I am promoting everyone.
All right, who have we got? Let's start with who's going to be for the city on this one? Joel?
No, I'm present, but I believe that first we're going to be hearing from there's a motion to continue and some other things. So I'm going to stand back until other people speak, I believe.
Yeah. I just want to know who's for the party so far. And who do we have for the applicant? Is the applicant represented tonight?
Yes, Maple Adams is Krieger is present.
Okay.
Mr. Chairman, if I may, before we begin, I'm going to recuse myself from being on this decision. Back in the summer, at a social gathering, I was in a conversation, more listening than participating, about this issue. While I did not, with one of the parties, and while I did not actively participate in any of the substance of the conversation, I do believe that it would be inappropriate for me to participate in it, given that the matter was discussed in my presence. So I will recuse myself from being involved in the decision.
Well, that's appreciated, Mr. Walsh. The credibility of our board is very important to all of us, I know, and to the community. And who do we have representing the appellants?
Good morning or good afternoon. First of all, congratulations on your election. It's always a good way to start. My name's Terrence Lomax. I go by Terry. I represent the appellants. There are 4 appellants. Actually, we need to let them in, I think. Should be Mr. Swirzler, Mr. Lanasori, and Mr. Bernard.
I
There's
think
Mr.
I see
Bernard,
at least.
I believe Mr. Ladazori and
Mr. Schwarzler is with them. Okay, we have everybody then.
all right.
All right, so welcome to this wonderful group, Mr. Lomax, and I see you haven't wasted any time with a flurry of paper coming at us. First, let me mention a couple of things. Our practice in these appeals cases has been, if you need to communicate with the board, you do it by motion, and you do it through Ms. Rouse. Nothing should go to the members of the board directly. We don't want to take any chance of someone failing to copy all the right parties and violating the ex parte communication rules. So that's one of the reasons we do that. The other is it's just more efficient. So is that understood, sir?
Yes, and I know better. And when I think when I filed this, it was either New Year's Eve or the day before New Year's Eve, because I had just been retained. And I think I simply picked up an email in which you were on the email, and it was a reply all, including Mr. Braithwaite and various others. So I apologize for that. I think that was probably just because of the email.
Okay.
You were on that email.
Now, I notice we have a motion for continuance pending. Rather than hear arguments on that now, let me go over a couple of things and still see if we still need arguments.
Mr. Gallagher, I have a question. Is Dr. Chen participating?
No, she's not.
Okay, I just needed to know to put her as a recusal.
Yes, I recused myself at the last meeting.
Just wanted to make sure that was still the case.
Thank you, Tammy.
Thank you.
Okay, in the papers, there's back and forth about whose fault these delays are. Let me just outline for everyone the process so you understand. When an appeal is filed, the director decides when the appeal has been perfected, when the application for appeal is complete. And when that decision has been made, our rules, and I believe the law requires that each matter be scheduled in order of filing. So you get your place in line just like everybody else with an application or special exception or variance, whatever it is. And it's set for hearing in that order when the board has time to hear it. The board has a regular monthly meeting, but for much of the past year, we've been meeting twice a month to try and clear up the backlog. So hearings aren't always as quick as they might have been. Also, I think Mr. Lomax, you mentioned that there was a delay resulting from that there's a prior continuance resulting from recusal, from a failure of a quorum. Well, that's correct. I think you referred to a right to have we have to provide you with a quorum. Well, I don't want to debate the merits of that, but just let me point out that the reason we didn't have a quorum is because your clients were contacting members of the board directly and they recused themselves. So it's also our policy on continuances. We prefer to have people represented. We're delighted to have you in the case representing the appellants. And it's also our practice, I hope to be codified in our rule changes at some point, that you get one free continuance. So you've got a continuance. The next one, if you need another one, it's not going to be so easy because we want to keep these cases moving. I know the applicant, she may be frustrated with us, fine. She may be frustrated with Department of Planning and Zoning. These things take a long time. I can't help that. We do the best we can. But she needs a continuance, she'll get one. So do we need any more argument on this? Mr. Braithwaite, Mr. Lomax, Ms. Adams?
And
Nothing from the city.
I will, submit to the board, whatever the next available date is fine. This was just because it came up over the holidays and it was just impossible. This is not trying to kick it out any farther than immediately necessary. And if the 20th is the date, the 20th is the date. It's whatever the board determines, we'll make ourselves available.
Ms. Adams?
Hello, Mr. Chair. I'm not frustrated with the board. I'm frustrated with the process, and I'm perfectly fine to to grant Mr. Lomax the continuation as he so wishes, and hopefully we can resolve this at the next board meeting.
Thank you. That brings us to scheduling. The next board meeting is on the 21st?
The 20th.
20th. And Jackie, what have we got on the schedule that night?
Well, we had already put this on the schedule for the 20th as a continuance of tonight. You know, that that was going to be actually when we just finished it up with the deliberations and all, but we could use that spot to have the hearing then.
So what else is on the schedule for that night?
I'm sorry.
Just the continuance of the variance.
Right, which is just the deliberations and the wrap up on the variance. And at this point in the time, those are the only two things that are on that agenda.
Okay, well, that sounds promising then. So we'll look at the 20th then. Let me also mention.
Excuse me, Mr. Chair.
Yeah.
This is Terry April. I did want to make sure the last hearing you had made it very clear to the appellants that no new information should be brought to the board.
Just getting to that.
Okay. Thank you very much.
I'm not sure. I know Planning and Zoning and Mr. Braithwaite are aware, but I'm not sure about Ms. Adams or the appellants. There's been a change. There was an ordinance passed back in the fall that changed the standard of review and appeals to the Board of Appeals from decisions by the director. The old standard was that it was a de novo hearing, and the board started over again and heard any evidence that anybody wanted to present that was relevant and made a decision without much regard to what the department had done. That changed. The new standard is review on the record. The burden remains with the appellants. The burden's on the appellants to demonstrate that either a reason that the record contains insufficient evidence on which a reasonable person could reach the same judgment reached by the director, or that the director made an error of law. So in all but the most exceptional cases, that means that there's no new evidence. We don't hear any witnesses. We don't get any new documents. The case is about whether the record that's been designated by the city supports the decision of the director. I'm not saying that there never could ever be circumstances where the board wouldn't hear evidence, but we would want to know well in advance why you thought that was necessary and what it would be. And we'd rule on it well in advance of the hearing so that everybody knows what's going to happen. So really it's an argument where you will go through the record and through the law, make your arguments in the case of the appellants as to why the record that's been filed doesn't support the decision, or that the decision is wrong as a matter of law. So is that clear to everyone?
This is Terry Lomax. Is there a reference to that ordinance? Because I went on the website and pulled up the rules, and I conferred with Jackie and was
it's ordinance 39-19.
39-19. All right, I'll pull that up. The other question is, and I fully understand appellate rules. I do other appeals too, but there are, for example, an exhibit of a drawing, which the appellants submit is incorrectly interprets the code, and the appellants would be inclined to submit a markup of that drawing Now, yes, that's a new exhibit, but it is essentially pointing out the error in the drawing that's in the record.
Well, you can do that in a narrative. Again, I hadn't gotten to it yet, but I would invite anyone who would like to submit in advance of the hearing a pre-hearing brief that lays the groundwork for what you want to do. And you could do that in there.
So let me just say, Mr. Gallagher, that the documents that were forwarded to the board as the record in this case have been forwarded also to Mr. Lomax so that he has the entire record at this point.
Yeah, he'll let us know if he needs something.
I don't think I need anything. It's just taking issue with what I have received in terms of its accuracy, in terms of its accuracy and what it depicts. That's all.
Yeah.
This is Joel Braithwaite from the Office of Law. I note that the 3419, Ordinance 3419 has been codified, so it's just regular. We just go to the city code on appeals, and the city code on appeals clearly says on the record. And so you don't have to rely on advice from anyone. You could just go straight to the city code.
Yeah, I misspoke, 3419.
Where and what section was it codified in? I mean, I could go back and pull up the ordinance. But it'd be easier
You're looking
to
at the Board of Appeals notice requirements for the Board of Appeals notice statute has on the record.
All right, so that statute's been updated.
Yeah, I think I sent you the link to the appeals chapter, Terry. It's in the chapter in the zoning code.
I know where to find the appeals chapter. I had just inquired about the board rules, but that's fine. It's
the rules have not, but we talked about this. The rules have not yet been updated. They're in the process of being updated and revisions, and then we have to determine the process for having a hearing on updating the rules.
Yeah.
Correct, Bob?
Yeah. Yeah, I mean, the law trumps the rules.
Certainly. And
That's
and
what-
we'll
that's what I wanna make sure
we'll comply. That's not an issue. That will not be an issue.
Yeah.
If I have something I think it needs to be submitted, we'll submit it well in advance, and maybe as part of a pre-hearing submission.
And Mr. Lomax, the city is willing to have a discussion about anything. So to the extent we can have stipulations of consent, we're willing to proceed by stipulations of consent.
I will do that, and I might be able to get it to you tomorrow, if not in the next couple of days.
So Bob, can we set a deadline for the submittal of pre-hearing briefs from either party? So that
I'd like to see them by the 15th,
okay.
so the board gets a chance to read them. And if you got any motions, get them in by then. Mr. Lomax, do you anticipate any issues with proper notice or publication?
Unless it's, I assume that the city will do the republication.
Did we, since we've already have the hearing was advertised for tonight as a preliminary hearing, I believe. No, it was advertised as an appeal application. So if we continue it to the 20th, I don't believe we would have to re-advertise it.
And
All right,
I would
Ms.
have.
Adams, do you have any problems with any of the notice or publication requirements?
No, I have no problems with it. The intent, however, hopefully, is not to have to put out information again. So I'm fine with it as Mr. Rouse has stated.
Right. I think the property has been posted, and we have the affidavits, and the notifications have gone out to all the interested parties as required by code, and it was advertised in the paper. And I believe we have affidavits that have been submitted to that effect. Is that correct, Sally?
Yes, that was all done for the December meeting.
Right. So we continued it to tonight from December.
Yeah,
So we're continuing it again till the 20th, which is the way that we've advertised it on the agenda. That's
okay. We got it.
Okay.
Just so all the parties will know, we've had one appeal so far under the new rules. We're still kind of feeling our way through. The way we did it last time, I think, worked well and makes sense. And so I would prefer to do it the same way. And that was that at the hearing on the 20th, the city would start by explaining what they did with appropriate references to the record. And then we'd hear from the appellants telling us why what the city did was in violation of the law or inadequate in some way. And then the applicant comes along and gets the last crack. If rebuttal was necessary, we could accommodate that, but that's the general order of things. Have there been any comments, public comments so far? I think there have been, right?
Oh, yes, you're right. There have been some. They're posted on eTrackit.
Right. So those will become part of the record. Tammy will be marking with exhibit numbers all the documents that are part of the record. And so she'll send out a list to everybody, so we'll all have the same sort of index and can refer to things by exhibit number if that's appropriate. Also, I would also suggest that in the last one, I think it was helpful that Mr. Braithwaite was open to suggestions from any of the parties to items that may have been inadvertently left out of the record. And, you know, a week before the hearing, I think several more items were added to the record. It's perfectly appropriate if you all want to do that. And it's helpful, in fact.
Bob, can I ask a question about that? But is the basis for the appeal remains what the original application and letter that came with the application is, or can
the record, Dr. Nash, is everything that you and your staff relied on in making the decision.
So even if it hasn't, if the appellants didn't mention it in their letter, but that
right.
their
right.
attorney is mentioning it now, they can bring it up, or no?
If anything you relied on, you ought to add it to the record if it's not in there already.
This is Joel Braithwaite from the Office of Law. I believe that there's a mixed match of questions and answers. Basically, Sally is referring to appellants, and it's almost like a restated notice of appeal.
Yeah.
On January 1, provided a letter to the city, while it is concise in its expression of appellants' issues, it introduces a new issue of something dealing with the Historic Preservation Commission. And in rereading the September 18th submission by the appellants, there was no mention of the Historic Commission, the Historic Preservation Commission, or any error alleged as to any interaction between the city and the Historic Preservation. So as to that issue, we will respectfully move to have that, to ensure that there's not a discussion of that, since it wasn't raised in the September 18th letter. And further, the city has a continuing objection to joint appellants where each appellant does not perfect an appeal. There's supposed to be 4 appeals that are perfected, and then the 4 appeals are joined into one joint appeal. This Office of Law is not of the opinion that the city code provides for different individuals to coalesce and become one appellant. And we have raised this issue before, and we'll continue to raise this issue in every joint appellant case.
If I understand the issue, I mean, there's no corporate relationship or other legal association among the appellants. They're all individual appellants, as far as I know.
And that'll be the point. So therefore, as to each appellant, each appellant must perfect its own separate appeal. And then we can have a joint appeal where if you have 4 perfected appeals on one issue, we join the appeals. That's the way the courts do it. That's the way everyone else does it. I do believe that in looking at the code, the only way the code provides for a joint appeal is if the action that the director took affected applicants jointly. So if there are several parties within an applicant, all of those persons are entitled to a joint appeal. When I say persons, I mean to include corporations in that discussion. But in the absence of there being a joint denial, there cannot be a joint appeal but for the perfection of 4 individual notices of appeals and notice requirements, and then they can be procedurally joined later. And that's a position that we took in the Eastport loss, and we're going to be reasserting that position here again.
But what's the practical issue here, Mr. Braithwaite? I don't get it. If one of them wins, they all win, right?
Conceivably, yes. And as to, so again, this is we have 2 different fronts in any appeal, right? One, it's the procedure. How do we get to having the board exercise its jurisdiction over the subject matter, and then the actual subject matter. So this is just a discussion of who's entitled to appeal, what must they do to perfect their appeal, and what does the law provide. And again, our position, you may say that it's a distinction without difference, but for us, it's one appellate, one appeal. And that's a position that's staked out in Maryland code and Maryland law.
All right.
And
let me probe a little more here, make sure I'm not missing something. Does the city contend that any of the individual appellants have failed to perfect their appeal?
So in a position where you have 4 persons attempting to appeal and they act as one party together, they seem to be a team, but just because you're a team, does that mean that the city code must recognize each and every appellant who is a part of the team? I do not believe that signing your name to a piece of paper gives you the rights to file the appeal, that there's something called standing. So if each of these appellants first have standing, then the next step is how do they perfect their standing for their appeal? And this, to me, to perfect their standing, each person who seeks to take an appeal must take affirmative steps to further that appeal, specifically following the city code. So I believe that based on everything I understand about the law, that joint appeals, again, are permissible if each person perfects an appeal. If one person perfects an appeal, then that one person moves forward.
Well, let me ask you again. Do you contend that any of them have failed to perfect their appeal?
I contend that 3 or 4 people have not perfected appeal.
In what way?
Because as to, there was only one notice of appeal filed. So I agree that one person has perfected an appeal, but there were not 4, so there cannot be 4 appellants.
Well, Mr. Braithwaite, I'm looking at the notice of appeal, and that actually the notice of appeal, the form itself was prepared by and signed by 2 appellants. Are you saying those 2, let's set aside the other 2 that show up on a later document. Is your contention that those 2 appellants, that's Mr. Bernard and Mr. Latazori, are not appellants, or that you have to pick and choose which one it is? They both signed the notice of appeal.
Yes, but each of us, that they were not entitled to file a joint form before us. So my contention is simply this.
Where is that in the code?
Where is the allowance of a joint appeal in the code?
Well,
it does not allow.
It's the city. I will suggest it's the city's form, and the city accepted the form, and it's the form that they're required to use.
Okay, I think there are 2 things happening.
I mean, frankly, the fact that one is in, but at least have the courtesy to tell me which one you think is in.
So when I read the application, the first thing I see that there is a person, I believe the name is Bernard, and Bernard's name is the first person you mentioned in your line when you say comes now. And it seems to me that Bernard is the lead, but as to each of the 4, if somebody else says, well, I want to stand in his place and they could come to an agreement, I have no issues with that. But I do believe that one appeal was perfected, but I do not believe that 4 were.
I beg to differ with you, because if an attorney enters their appearance and files an appeal on behalf of multiple parties, those parties all are designated as appellants. So, but we don't need to take up the board's time on that. But I just at least need to know if you're going to file a motion, that's fine. I'll respond. And that at least Mr. Bernard is the one that you're opting to say would be the one that's in there.
Again,
right?
Again, I just want to, I'm just making a procedural argument that only one person moves forward. As to which one, I defer to the board. Mr. Bernard's name was first. If that matters, then it matters. And if it doesn't, then it's just whether the board believes that the city code allows for a joint appeal to proceed in this way. And I don't believe the law allows it.
If you want to file briefs on it, fine, we'll read them and we'll decide. My, off the top of my head reaction is that it would be silly to say that they can't file the same form. If the name's on the form, they complied with the timeliness. I understand your argument that names added after the filing deadline, you've got an argument there, but you've got at least 2 people whose names are on the form and filed timely.
Mr. Chair, I don't think as the applicant, we're not taking a position on that particular issue, but we will be filing a motion on the 15th with regard to the discussion that's been had with regarding the HPC.
All right, let me turn to that. As I recall, the law that refers to the application for appeal, it says you got to state the grounds for your appeal. It doesn't say what level of detail you have to go into. Some people who think you don't need a lot of detail would analogize it to notice pleading. Others would say you've got to basically file your post-trial brief in your notice of appeal. The fact that the HPC was or wasn't mentioned in the notice of appeal, I'm not sure is determinative of anything. In reading through the record, as I've done, I saw that, and that was certainly a question that I thought needed to be answered. So, you know, again, if you want to focus in on that, that's your right to do that, and we'll decide. And
yes, and part of that is because the HPC doesn't have jurisdiction necessarily.
Yeah, all right, we don't need to hear that now.
Yeah.
And that is part of the record.
Sorry?
I just want to make sure, because I believe I recall that the HPC division, not the HPC board, the HPC division of Planning and Zoning submitted its comments in response to the application. And that is, I believe, Dr. Nash, that is included.
It's in the record.
Yeah, okay.
It's in the record.
The Office of Law position on this is it's simply September 18th is the timely file paperwork. Whatever's on the September 18th paperwork, it actually, Chair Gallagher, even your comments about, well, at least 2 people were on it, so you believe that they're joint. Then if you apply the same rationale, then it certainly excludes any new arguments. And then the January 1 submission, first sentence regarding the HBC is a new argument. We are entitled to notice as to what the errors were, and only the errors alleged are the errors that are subject to discussion. This is not a de novo appeal, and they cannot bring up new errors or stuff or errors now with the appearance of counsel. Maybe this is the reason we retain counsel from the start, to make sure that we have covered all our bases. But counsel comes in on January 1. Counsel is bound by the prior pleadings and the September 18th notice, which does not have a discussion of HPC. There was a general allegation and 2 specific allegations of a code violation, and then also also as to the bulk ranks. Those were the 4 points in reading the September 18th letter, and I believe they must be bound to those 4 points raised.
And I would completely disagree that whatever is in the record is fair game at this point.
I'm not going to rule on that now, but Mr. Braithwaite, I think it would be a mistake for you to ignore that issue in your preparation and in your pre-hearing brief. Is that clear?
We were already over it, all over it.
Okay. Is there anything else we need to talk about on this case?
Question, Mr. Gallagher, may I ask a question?
Sure.
Is there a point at which the appellants can cease to bring forward any other issues which they wish to attach to this appeal? Is there a point where something cannot be added, or no?
It goes back to the unsatisfactory explanation I tried to offer a few minutes ago. What the rule says is that in the notice of appeal, you've got to state the grounds for the appeal. It does not say how specific you need to be. Some people would say if all the appeal notice says is that the director's record doesn't support her decision or that it's erroneous as a matter of law, that's enough.
I know, but there's not up here, so I thought maybe we had some of the.
Somebody mute. Jackie, mute.
You have chips, or you can have some.
Jackie, mute your audio. If I can't have chips, no one can.
I'll
All right.
second that.
Anything else we need to discuss on this case tonight? Wonderful. Thank you all. Briefs and motions by the 15th, simultaneous. Mr. Lomax, is there something?
I just want to ask Joel, are you in the office tomorrow? Because maybe you and I should talk and at least try to streamline, if not simplify things.
Not a problem. I believe we could agree on the set of facts, and I'll reach out to you tomorrow, probably tomorrow afternoon, and we could at least have a stipulated set of facts, and then whatever our arguments are, arguments.
Whatever you will, just reach out to me before 2 o'clock. I've got to actually.
I would like to be in on that call also.
Look, we've got one counsel representing the appellants here.
Yeah, yes, and I believe Mr. Averill is representing or working with the applicant.
Yeah, absolutely.
Oh, sorry, Mr. Averill, you weren't introduced before. I beg your pardon. Okay, anything else?
Nothing from the appellants.
Great. Thank you all very much. Look forward to seeing you on the 20th. Look forward to you resolving this so we don't have to see you on the 20th.
Touche.
Mr. Gallagher, what was it that you asked them to provide by January 15th? I'm sorry, I missed it.
Pre-hearing briefs and motions, if any.
Thank you.
Thank you, Tammy. All right, Ryan, if you, we can excuse the parties to 2006 and we'll bring on 2004.
All right, sounds good.
So Tammy, you'll be marking those public comments for 2006.
So I sent you all of the exhibits, a listing of everything that I
did you? Okay, all right.
For this appeal. And I probably should send Mr. Braithwaite, or I guess the appropriate city spec. I don't know exactly who to send it to, but just so that they can look them over and make sure they're in the appropriate places. And also if there needs to be anything added or deleted.
You can just send it to me, Tammy. Thank you.
Sally, I did send it to you.
I was going to say, you already did actually. So
yeah, so if you could, check that out. And before I distribute it to everybody, if you could check it out, make sure it's in the right place. And then we can kind of distribute it after that, I guess.
Okay, I will do that.
Thank you, Sally.
All right, I thought I lost everyone there.
Oh, somebody was screen sharing. Why they were
Weird.
Yeah.
Yeah, well, it's impolite to share a screen of a COVID germ. Okay, this is Appeal 2020-004. And who do we have for the city? Is that Mr. Braithwaite?
So the Office of Law, we proceed through the director, I believe.
All right, good. And for the appellants, we have Mr. Nelson again. Is that right?
Present, thank you.
Thank you. And for the applicant, Mr. Christoph, I think you're mute. I'm still not hearing you. Ryan, is that your end or his end?
I'm not quite sure. I can ask him to
He's good now.
unmute. All right.
Tony, can you hear us? Can you? We can't hear you.
It went on for a second.
Can you hear me now?
Yes. Good. All right. So I know I'm not really directing this to Mr. Braithwaite, but Mr. Nelson and Mr. Christoph, you're aware of the change in standard of review in these appeal cases, are you?
Well, I appreciated the chair's description of it. I wasn't familiar with it, but I took notes and I'll look at that very carefully. I'll be ready on that issue.
Okay, Mr. Christoph, you're good?
Mr. Chairman, my understanding is that the appeal is now on the record, not de novo. I do have a point on that based on the previous hearing, and there is a document missing from what I perceived to should have been the record as filed by Ms. Rouse in this case, and that is actually the actual letter of June 1, 2020 from Leo Wilson of Hammond Wilson seeking the modification to the site development plan at issue, as well as the revision supplemental information form. So I would ask leave of the board again, based on your previous discussion on the previous case, the ability to file that, or maybe just ask Ms. Rouse to assure that she sends that forward to the board.
Yeah, just ask the city if they'll include that in the record, and if they're agreeable, we don't have a problem.
Thank you.
If they're not agreeable, we'll figure it out.
Mr. Christoph, would you mind emailing me that and I'll make sure it gets out?
Or I will. I mean, I don't know why it didn't get included in the record. I thought I had sent everything we had, but be happy to. If you could just send Sally and I an email, I'll send it out tomorrow morning.
May I be heard very briefly, Mr. Chairman?
Sure.
I would request the opportunity to speak with Mr. Christoph about that issue tomorrow morning, first thing.
Don't have to ask me for that.
I beg your pardon?
You don't need my permission to talk to Mr. Christoph.
Oh, no, but before he emails it to the planning department, I just want to see the document that people are assuming is in the record. I'm not saying it's not. I just want to see what document we're looking at. That's all.
We're not assuming anything, but if the city says it's in the record, it's probably in the record. They're the ones who decide what they relied on.
Right. My only point is that an advocate for one party in this case made a representation, and I'm asking for the opportunity to look at the document before the tribunal acts on it. That's all.
No one's going to sandbag you on that.
Thank you.
If I can respond, Mr. Nelson, the documents I'm talking about are the actual letter of June 1, 2020, and the revision supplemental information form from which you took an appeal.
All right. Well, I mean, I'll look at the document.
Good. Okay, so Mr. Nelson, in light of the new standard on appeals, I'm prepared to extend to you an opportunity to revise your notice of appeal if you'd like to do that.
I'll accept that.
And when do you think you can have that?
I want to be respectful of the board's schedule. I'd appreciate 2 weeks, but if 2 weeks is too long, I can live with a week, but I'll defer to the board.
Why don't you try to get that to us by the 20th?
Thank you. I'll do that.
That's close. Probably won't be reading it before we read all that other stuff anyway. And again, if anyone thinks anything's been left out of the record, I encourage you to discuss it with each other. Are we going to have any disputes about standing or notice or publication? Anybody?
Not on behalf of the applicant.
The appellants are aware of no such dispute.
Mr.
The city is
Braithwaite?
not yet
or-
aware of any facts that would that I'll create those allegations. If we do become aware, I'll speak with Mr. Chris Hilf and Nelson, and we'll try to work it out or file motions.
Good.
So can I ask this was advertised as a preliminary hearing on the scheduling order, so we would need to re-advertise and repost the property and re-notify everyone when we decide upon a hearing date. Is that correct?
Well, or we can pick a hearing date and call it another scheduling conference and then move from there. It might save people some trouble and money.
Okay, okay, that's fine. I just wanted to clarify that.
Why don't we make it January 20th and ask everybody to submit a status of where they are. You don't have to even show up if you want to submit it in writing.
But then we're going to have, on January 20th, we would then be setting a date on the 20th for when we would have the public hearing?
Yep.
On the merits?
Yep.
So I think in the past, when we have moved from the preliminary hearing to the public hearing on the merits, we have re-advertised.
Well, I mean, if you think you need to do that.
I'm just saying, I think we did this once before when we had the same situation. We did. I don't know that we have to do that. I'm just mentioning that. I just want to don't want there to be any confusion on everybody's part about when we're having the actual public hearing on the merits and for the people to feel that it was not properly advertised, especially the general public.
Mr. Chairman, if I could be heard, my understanding of the purpose of this hearing, as indicated, was that the public hearing schedule would be announced. The purpose of this hearing is to set a hearing on the merits.
Well,
once we sense in another preliminary hearing to then set another hearing after that. And particularly, it would seem to me that notice was required for this hearing to anyone who is interested. So anyone who is interested would be participating and would have knowledge of the public hearing as set by this board this evening.
All right.
On the merits.
We'll do that. Whether it'll actually happen or not, I can't promise you, but we'll do that.
Thank you.
Let's see, Mr. Christel for Mr. Braithwaite. Anyone thinking about any motions to dismiss the appeal?
Unless they're joint appeals or they present new issues, I don't intend on filing motions.
Okay.
I don't intend on filing one on behalf of the applicant, Mr. Chairman.
All right. All right, so again, you heard me talk about our order of presentation. We've been doing the city, the appellants, the applicants. Jackie, what's the schedule look like February?
Well, we don't have any definitive things to advertise for February 2nd, although I will note that we do have some cases in the waiting line to be scheduled, but we could probably schedule this for February 2nd. There's nothing definitively scheduled for February 2nd, in other words.
Let's consider this scheduled for February 2nd.
That is Groundhog Day. Is that a problem?
Mr. Chairman, may I be heard briefly?
Of course.
I'm available February 2nd, but I have a very significant case the next morning in a very substantial case, and I know that sometimes these cases go quite late. And my question is, could we do it? Is there another day close to that date that the board's available?
The only other meeting time we have in February is February 17th.
And what's on that schedule?
We don't have anything. It's the same situation as the 2nd. We have a lot of items in the queue, but nothing specifically scheduled for the 17th.
On behalf of I'm sorry, I didn't mean to
Well, I was just going to say that in our limited experience so far with this new standard of review and appeals, it doesn't take very long. I mean, most parties don't need more than 15 or 20 minutes.
Well, the other option, Bob, is that we could schedule it for January 20th.
No, we just scheduled 06 for the 20th.
I understand that, but if that one's not going to take more than an hour or so, we could probably do both of them. We don't have anything else scheduled for the 20th either, other than the deliberations.
This one's more complicated. I want to see good brief.
Mr. Chairman, in view of the chair's comments, February 2nd, we'll make it work.
Okay, so let's figure out a date for the pre-hearing briefs.
I thought you just asked for those to be submitted by the 20th.
Did we do that? Is that what we had? All right, that's fine.
No, I thought that was a revised appeal.
That was a revised appeal, Jackie. You're confusing me.
Okay.
But, so January 20th, February 2nd.
A week before the meeting would be January 26th.
Yeah, can we do it by the 26th?
Oh, I'm sorry, acceptable to the citizens.
Acceptable to the applicant too, Mr. Chairman.
Great. Joel, can you live with that?
It's always a good day for the city.
I love this guy's attitude.
All right, and if there was, if we had the revised appeal before the 20th, that would also be helpful. It would give everybody a little additional time to review the revised appeal before preparing their briefs. Correct, Bob?
Yeah, try and move that back a couple of days. Can we, Mr.
Let's make it the 18th.
Can we do that?
We'll do that.
Great. All right. All right. Is there anything else we need to do in this case?
Mr. Chairman, if I could, by way of clarification, in light of the new standard of review, we discussed the one item which I think has not been included in the record to date, which we have remedied. Can additional items be submitted because of the change in the appeal now being on the record? Just asking from either party.
Let me say this again. It's the law gives the director the responsibility for transmitting the record that she relied on to the Board of Appeals. And she's done that. And sometimes she makes mistakes and she'll find something that she's left out. And we liberally allow her to amend that. We also encourage other parties to the case who think she may have left something out to bring that to her attention and see if she will agree to add it to the record. If she won't add it to the record and you think it's something they relied on and they're just putting their head in the sand, well, then you can raise that by motion and we'll deal with it then, but that's never happened before.
Thank you.
Okay. Well, thank you all. I didn't expect this pleasure to have you all back again, but here we are, and we'll see you again on February 2nd.
Thank you. Good night. Thank you.
Good night. Happy New Year to all of you.
Thank you.
All right, Ryan, we've got a variance now, I think.
Yep, they should already be added.
We'll excuse these lovely people and bring in the variance parties.
I think both Amy and Douglas can turn their cameras and microphones on.
Hello.
So would you like an election update? The 20% of the vote is in,
Yeah.
and Warnock has 53 and Loeffler has 47. And I think the numbers are roughly in the same proportion with Ossoff and
Interesting.
yes, so the Democrats are leading with 20% of the vote in.
Interesting. Okay. Tammy, that didn't happen. Welcome everyone who's here on behalf of variance 2020-007. Who would like to present this case on behalf of the city? Is that Kevin?
No, that's me. That's Cynthia.
Oh, Cynthia, right, of course. Archwood, right. You're the Archwood person.
That's correct. As you stated, this is variance application VAR 2020-007. The applicant is the property owner, Douglas C.K. The location is 121 Archwood Avenue. This property is zoned R2, which is a single-family residence district. It is within the critical area with the designation of IDA, which stands for intensely developed areas. There's no critical area concerns with this application. The application is for a reduction to the required 6-foot side yard setback by 3.67 feet to 2.33 feet, which is the existing interior side yard setback on the northeast side of the property. The request is to build a covered front porch and to align that front porch with the existing side yard setback. This is a property that was built around 1936. The yard itself, the property itself, is not conforming to the required width. For the R2, it's only 45 feet wide in lieu of the required 50 feet wide. That's probably one of the main reasons why it can't meet the required side yard setback.
Right.
Do you have any for me, or would you like to move to the applicant at this time?
Any questions for Cynthia from the board?
Nope.
Cynthia, the footprint is staying the same?
No, because they're building a front porch. They're coming forward and building a front porch.
Coming forward, okay. And do we need a setback there?
They did need a reduction to the required established front yard setback. That was done through an administrative adjustment.
Okay.
It met the criteria for administrative adjustment. That was reviewed and approved in November.
I understand.
So
All
it's
right.
just the side yard setback for the Board of Appeals to hear.
Is there someone from the applicant who would like to be heard?
Looks like Mr. Walsh had his hand up.
A quick question, Cynthia. It's a through lot. Does that
It
allow
is.
you?
Yes, it is a through lot. It's a through lot that runs from Archwood to Amos Garrett.
Right, and that gives you the administrative ability to grant that that allowance in the front.
Well, it's on the Archwood side. It's on the front. It's not on the Amos Garrett side. It's on what would be viewed as from most people as the front. It is a double, as a through lot, it is a double fronted lot, but you know, the front of the house faces Archwood.
Correct, yeah. Okay, thank you.
You're welcome.
All right. Would anyone like to speak on behalf of the applicant?
Sure, I'll say something. I'm Amy Taylor. I'm the designer working on Doug Kay's proposed project, which is we're hoping to do improve the curb appeal of the home, but also provide a place to sit in front of his house and be under roof as he's entering the home, and also all trying to stay behind. It's actually in line with the existing stoop of the house. So we haven't tried to go out any further than that. But he's trying to create a space where he can sort of connect to the community. And we're trying to stay true to the Cape Cod style with very simple white columns and simple square details and potential metal standing seam roof. And fix, there's a nice old sun porch on the side of the house, but there was an addition built in the back that I think sort of messes up the facade of the house in a way. doesn't look right. So I think that extending the ridge line of the second story of the house and then providing this new porch with a different pitch in the roof sort of brings it all down in scale and improves the overall look of the house.
Well, it's a very nice looking house in a wonderful street on a wonderful neighborhood. Happens to be my neighborhood.
Oh, nice.
Is it Mr. K or the neighbor next door who must be a concrete or masonry contractor?
I think it's a neighbor down the street.
Oh, is that it?
New neighbor. Yep.
A lot of concrete there.
Yep.
Okay, any questions from the board for the applicant?
There was a couple of conditions that were made set forth by the cities. The applicant reviewed the conditions and agrees to comply with them. Should the board grant this variance?
Yes.
Yes.
Okay, do we have any public comments? Cynthia?
No comments have been received. No public comments have been received.
Okay, and Tammy, so you'll mark the staff report, or you've already done that, haven't you? And the attachments. Very good, that'll become part of the record. The process for the applicants is that under this virtual process we have, in order to give anyone who's listening tonight an opportunity to comment if they choose to, we can't make a decision tonight. We have to leave the record open until our next meeting, which will be on the 20th, and we'll decide then. You're welcome to join us for that meeting or not, doesn't matter. But we thank you very much for your patience and your presentation, and you'll have a decision on the 20th.
Thank you.
Okay. Great, thank you.
Thank you. Yeah.
I'd like just to add that, the property was posted as a double fronted lot or as a through lot. It was posted on both the Amos Garrett and the Archwood side. The newspaper ad was placed and the mailing notice was sent. Originally, this project was scheduled to go to the December 16th hearing. It was brought to our attention that an error was in that mailing notice that went out for that time. And so we pulled it from that hearing date and moved it from here and reposted it and did all the notices as necessary.
Well, we apologize to the applicants for the delay caused by our mistake, but
no problem.
It'll all work out for you fine.
Bob, I do want to just get my one request that we take the minimum relief requirement as our sort of cornerstone. This porch that you're seeking to request, I understand that the door to the house is right side justified by the driveway, and that you made mention to the addition by the side porch, but you're asking for relief on the left side, I'll call it the left side, from the street perspective to that side yard setback. Can you explain why it's necessary to go the full width of the house? Is this an architectural imperative? Why do you need to go all the way over that far?
Christian, the relief is from the right side of the house.
The driveway side.
If you're standing at the street and you're looking at the house, the existing 2.33 feet is from that side.
Oh,
and
okay.
That is from where the door is.
Then it's because where the door is. I don't need to, my question.
That is correct.
Okay, my question is answered. Minimum is an understatement. It's the only relief that would work.
Yeah.
Okay.
Okay.
Okay, thank you again.
Thanks for that help, Cynthia. I don't get to look at drawings very often.
Good night.
Okay, is
All
there
right,
anything
if
else?
Brian would excuse folks on 2007, we've got a couple of other short business items and we'll be out of here in a few minutes.
Thank you.
Good night. Let's see. There were two little process things I wanted to deal with. And maybe we've already done this, but we'll get it in the minutes anyway. In order to physical signing of things has been complicated by the pandemic stuff. And I think not everyone is always comfortable with the idea of calling in approval for someone else to sign. So one idea that's come up is that whenever we have three conditions: a unanimous decision in an uncontested case that involves an application for a variance or special exception, no appeals, no contested cases, and no cases that are not unanimous, that I would review them and sign them without bothering you guys.
Fine with
That's
me.
permissible?
I agree.
Yeah, it's fine.
Okay, then fine.
Are we good with that? Okay. And there are four in that category, I think, already. We've got the Cat and Dog Hospital, Monroe Court, Murray Avenue, and Creek Drive. And but the process is that Cheryl is drafting these, and she follows a form that we've been evolving since the end of Gary's time, where we pretty much follow the same form in every decision and refer back to the staff report and the exhibits and the evidence and testimony given at the hearing.
Less is more in those opinions.
Yeah, I think so too. Okay. All right, so that's one item done. You've all had the latest revision. I think you've all seen the latest revisions of the Lofts decision. Would you all like to authorize me to sign it on behalf of all of us? And I'll get it to Jackie tomorrow and we can finally get it out.
Well, I approve the draft as written, so yeah, I certainly allow you to authorize on my behalf.
I agree.
And Bob, you've accepted my one small.
Yep, you're in there. You're in the same paragraph with Andrew.
Thank you. The smartest paragraph in there, I might add.
Okay, we're good with that, Andrew?
Yes, sir, Mr. Chair.
All right, now our rules revisions. We've had comments from some, but not all of you. I appreciate those. We have submitted to Mr. Braithwaite for his comments and left it to his discretion as to whether he would like to authorize Cheryl to go over it. That's up to him. If City Council's office, City Attorney's office is happy with it, that'll be fine with me. But we've also asked Joelle to look at the question of whether, under some murky language in the 3419, the ordinance that changed the standard of review, we're required to get City Council approval. I don't think we are, but we'll do whatever City Attorney tells us to do in that regard. If they conclude that we're not required to get City Council approval, you'll recall that rules, once we agree on them informally among ourselves, we have to publish it and have a public hearing where anybody gets a chance to tell us what's wrong with them and how they should be fixed. So before we get to that stage, even if we're not required to get City Council approval, I think it might be politic of us to send a copy of the draft around to the members of the council and say, if you have any thoughts, can you get them to us, in 10 days or 2 weeks or something like that. And then depending on where Joelle comes out, we will get the thing on the agenda for an upcoming meeting. The rules really are out of sync with the way we do things, particularly on the point about the standard of review on appeals cases and according party status to applicants and a number of other things. So I really would like to get them done. So is everyone comfortable with that sort of process outline, or any suggestions for improving it?
No.
No.
Okay, good. Joel, do you think we can hear back from you sometime soon?
Yes, we're reviewing that. We're reviewing that issue now, and we'll be getting back to you with a written decision.
Great.
So can I ask a question about the advertising of the rules? Does that have to follow the normal 15 days in, we're in advance thing, or can we advertise it like a week in advance? Is there a process for that?
I don't see any upside to making it less than 15 days.
Okay.
Why invite people to wine if you don't have to?
Well, I don't know, Bob.
I would
Waited
accept
this
an
long.
invitation to wine.
Oh, I'm pretty confident we'll have comments from a lot of the regular practitioners.
Okay.
You can guess who they will be.
So are we adding any rules with regard to appeals?
Yes, there's a set of rules in the revision about disclosure. Actually, I better go back and look at them again in light of the note. No, I think I drafted it with the note. The general rule is no new evidence. That's in there, but it does tell people we want briefs and things like that.
Well, let me just note that I was looking at the rules of procedure for Baltimore County on appeals today, and they have a rule that says that an applicant or an appellant can represent themselves in an appeal, or they can hire an attorney, have an attorney represent them, but they can't have anybody else.
Well, that's the law now, and our rule would change that. If if Mr. Rogers wants to have someone speak on his behalf who's better able to make his case, I think we would all be open to that. I don't know why we have
So
to.
he wouldn't just have to have an attorney, he could have anybody.
I would, given the local nature of many of the things we're hearing, I think having it, if you have a friend who's an engineer or an architect or it certainly would affords a more flexible, professional presentation without the burden of hiring. No disrespect to my attorney friends who need to eat.
We want to make this a warm and friendly experience.
Yeah, that's right.
The new standard of review, I think that's fine. I mean, it makes for a more effective and efficient process. So I see no reason why somebody couldn't be represented by.
And if the board, at the board chair's discretion, if it was wandering far afield from productive, you would have discretion to rein it in.
Yeah.
Sure.
I actually thought the whole process.
The rule would require any lay advocate who does that, and any attorney as well, to read our rules, and by appearing, they certify they've read and are familiar with our rules and will comply with them.
I love that rule.
All right. Happy New Year. Who wants to make a motion?
I'm waiting for the wine motion. Bob,
Are all the opinions finalized? That was the last question I had.
Yeah, I will sign them and scan and send you the signed page from each one.
Jackie, I did read all three of the opinions, and I was just embarrassed to reply so quickly that you were okay to sign, because it was about 2 minutes after you sent them. And I thought, I better wait a minute to show some thoughtful consideration. I never got around to following up on the email.
So you're only going to scan the last page? Because I only have 2 of the opinions.
Well, Cheryl will get them to you.
Okay.
Electronically, because she's the official keeper of the keys.
We've had some.
I did send them to you.
Again today?
And yesterday, yes. I don't know what's going on. You were.
I don't know what's going on. We had a whole breakdown of our whole email yesterday. That I'll talk to you in the morning about it. But I did not. Even after we talked today, I didn't get 2 more.
Okay.
Okay.
There's some breakdown between
all in favor.
Aye.
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 Thank you.